Hey, welcome everybody to Lunch with Legal. We're going to be reviewing the February 2026 and the March 2026 OAH cases. So these are the two most recent releases of OAH due process cases that we've received. We're so excited to have you join us today. And for those of you that are still on break, thank you so much for joining us on break. Just a little introduction about our firm. We are Hire Gutierrez LLP. We work with school districts across the state, and we primarily support school districts in the area of special education and student matters before OAH, state court, federal court, really anywhere and anything that involves students. So just a brief overview of the OAH decisions that we have from these 2 months. We have 8 decisions from February, 7 decisions from March. And of these 15 decisions, the school district prevailed fully on 11 of these decisions. There were 3 expedited cases and also 3 consolidated cases. And a consolidated case means that there were 2 different complaints filed and it was consolidated into one hearing. And because there's 15 cases, we each picked 2 cases that we think are particularly important that we want to talk to you all about. And that have interesting takeaways for school districts. And so I'm going to get started here with our first case. This is Student versus Stockton Unified, and this was a cross-filed case. So the student filed against Stockton on a number of issues. Stockton filed against the student, and specifically Stockton filed to exit the student from special education. And if you attended our past trainings, you know that exiting a student does require parent consent or judicial consent. And so in this case, the parent did not agree to the exit, and so Stockton filed. The student was 7 years old in first grade. He was eligible under SLI, speech and language impairment. Since age 2, the student had an autism diagnosis. And so in the spring of kindergarten, so in March 2025, the parent requested a reevaluation to determine whether the student met autism eligibility criteria. So Stockton offered a comprehensive assessment plan, including academic, health, cognitive, motor, social, emotional, adaptive behavior, and also speech and language, so communication. And the parent provided consent to the assessment plan at the start of April last year. So the team then met in August near the start of the 25-26 school year to review the assessment results. The assessment recommended that the student exit special education. And so this really was the primary issue that was at issue here. Is the student still eligible for special education? So regarding the parents' concerns regarding autism, the assessment acknowledged that the student did have the autism diagnosis, but the student also had appropriate eye contact. He followed instructions well, he communicated well, he had positive social engagement, followed routines, transitioned smoothly. So all of these are pretty strong indications to Stockton that there was not an educational impact of autism. And so the student had been eligible under SLI. And so part of this also was a speech reassessment. And so in speech, there were no abnormalities of speech and oral motor. The articulation was average. Oral and written language, receptive and expressive language, average, average, average. There was a very mild stutter. It was classified in the range of not noticeable to very mild. And so even the speech assessment recommended an exit from speech services. And so the parent, Stockton, ultimately won and prevailed in showing that the student did not require special education and related services. The parent had a few reasons that OAH analyzed that are interesting to talk about. So the parents said that the student had difficulty with morning transition. So keep in mind, this is a first grader. And the witnesses, though, testified that these were just minor difficulties and that these could be resolved with support available in general education. So again, this did not show a need for special education and related services to support transition. And as I mentioned, the assessment itself considered transitions and said that transitions went mostly smoothly. The parents also had health concerns around the student's constipation, and OAH found that this did not require an IEP to be addressed, that it could be appropriately addressed through 504 accommodations, such as those that were proposed by Stockton. Parents had concerns about bullying, but again, the decision notes that there was just one incident and that it was promptly addressed by staff and it did not reoccur. So there is one really surprising conclusion here from this Stockton case that I also want to highlight. It's just an interesting anecdote for OAH decisions and the reasoning and ordering remedies. So you have this conclusion that OAH agrees that the student does not require speech services any longer, or really any IEP services any longer. But then OAH also ordered a compensatory remedy of 1 hour, just one little hour of speech services. So how can it be? I just don't understand how it can be that at the same time you can say a student does not need speech, but also a student needs 1 hour of speech to compensate educational harm. That part to me is really difficult to reconcile. And it's also difficult to understand how a shortfall of implementation of just 1 hour of services can be material. But apparently this judge thought otherwise. My second case here is Parent versus Cupertino. And this case is somewhat of a landmark, perhaps, because it is the first OAH case that exists, and I searched this, that says that a parent is a vexatious litigant. And so vexatious litigant is sort of a term of art. It's a phrase also defined more concretely in the civil code, having to do with somebody that just abuses the legal system to harass someone through lawsuits. And again, this is the first, and to my knowledge, I searched the only OAH case that says a parent is a vexatious litigant. So let's look at what happened here. So in about the time span of one school year, this parent had filed 7 different due process filings against Cupertino Unified. And the due process filing that was at issue here was a 74-page complaint with 70 different issues. And all but 3 of those 70 issues were identical to a previous complaint. And things got to the point where Cupertino went to the pre-hearing conference and told the judge, we're not even going to show up at this hearing. That's how little merit we think this case has. We're not even going to defend it. And Cupertino won on all issues. And the judge also noted in his decision that the parent submitted 4,000 pages of proposed evidence exhibits, and that the testimony was difficult to follow, conspiratorials, and the parent would break into invectives against Cupertino. So a lot of times we get asked the question, at which point is this harassment? At which point is this a vexatious litigant, right? This is the one and only case that defines the term in the context of OAH litigation. And as you can see, the bar is quite high. It is also impressive that Cupertino did not show up to this hearing at all and still prevailed on all issues that the parent raised. So our next case is going to be involving Glendale Unified.
Good afternoon, everyone. My name is Michelle Breitmeyer, and I'm one of the attorneys here at Hire Gutierrez. I'm going to go through this first case. It comes to us from Glendale Unified. It's a very short case. It just has one parent filed issue. It was one of the expedited cases from this round of hearings. It involves the dispute between the parent and the school district on disciplinary placement for the student. So since it was an expedited hearing, the hearing had to take place within 20 school days. So there's a really quick turnaround on these kind of cases. The facts involve this school year. So all the allegations come from this school year. The student is 6 years old and he's currently in the first grade. He does not qualify currently for special education. The district has provided parent with 2 assessment plans this school year, but parent refused consent. So the district contends that he was not entitled to a manifestation determination upon 10 days of removal, but they also contend that the student was not removed from school for 10 days. So that's the main part of the case, is that student was not actually removed for 10 days from school. So the student contends that he was removed for 10 days. And his first allegation of that is that he was switched classes 3 times. So in this one school year, he went to 3 different first grade classes. The first class, he filed a complaint against the teacher for some behavior issues that the student had. The second class, he filed another complaint against the teacher for some other disciplinary issues. And now he's in his 3rd class. And the ALJ held that these aren't disciplinary removals. These aren't 3 days of disciplinary removals because they were parent initiated. The parent wanted to move the student. The parent wanted to have the student attend a different class. So the ALJ held that those were not disciplinary removals. They were not staff initiated, and they did not count towards the 10-day removals. The second allegation is that the student was a frequent eloper and he was often outside of his class. And while the parent does not necessarily state how many days the student equated to being outside of the class, he does say that it was a pattern of removals and it was due to behavior. And the ALJ held that, yeah, it is due to behavior. The elopement is due to behavior. However, it was not due to staff removal of the student. The elopement was student initiated and not staff disciplinary initiated. And the third allegation the parent had was that they picked student up frequently due to his behavior, and that constituted a removal as well. But the ALJ held that these were parent initiated pickups, that the staff did not call parent, the staff did not request that student be picked up early, that they were staff initiated parent pickups. And there's some examples in there about the brother who was an adult being on campus, witnessing the student having bad behaviors and taking the student home. The parent did not provide any evidence that the student was picked up early based on school request. But interestingly, the parent actually refused to testify in this case. And the ALJ, there was a subpoena for the parent to testify. The ALJ ordered the parent to testify, but the parent would not testify. So the ALJ ultimately let the district's attorney question the parent and the parent to object to every single question. But parent did call 12 school employee witnesses, and those 12 school employee witnesses testified credibly that none of these removals were based on staff initiated removals. That student was switched classes because of parent request. That student eloped on his own and was never removed from the class based on an elopement. And then he was never requested to be picked up early. So the ALJ held that for the district in this case, that student was not entitled, whether he was special education status or not, was not entitled to a manifestation determination. And the district ended up prevailing on this case. Our next case is a super long case. It has a lot of issues, and it comes to us from Coastal Academy Charter. I'm only going to go through one part of one of the issues. It is a really long case. In this case, the student is in the 10th grade. He has been attending Coastal Academy Charter since he was in kindergarten. The issues in this case revolve around his 9th grade school year. And the program of Coastal Academy Charter is described heavily in the ruling, and ultimately the student has some home learning where he's taught by his parent, some virtual learning where he's taught online, and some in-person learning on campus. And so he comes to campus for 4 of his classes. They're all general education classes. He comes to campus for American Sign Language, health, band, and biology. So in those classes, he is primarily with general education students and receiving general education curriculum. The issue that we're going to talk about today revolves around his biology class. It is what they call a co-lab biology class, and based off the ruling, co-lab is determined to be a co-taught class. There was a general education biology teacher in the class, as well as a special education teacher in the class. But primarily the students were general education, and the curriculum was 9th grade biology general education curriculum. And in January of his 9th grade year, so halfway through the school year, the district held an IEP meeting and they changed the student's placement to be in their functional academics class for all of his classes, including biology. And this issue actually revolves just around the biology class. There were other issues about other classes, but we're just going to talk about the co-lab biology class, which is a co-taught biology class. Parent contends that that was his least restrictive environment and that he should remain in that co-lab biology class. The district, the student's general education teacher, testified that student was not receiving any benefit from this class. He could not understand the higher level complexities. Student was intellectually disabled. His reading and writing level was that of a kindergarten to 1st grader. So the teacher contended that he could not get any academic benefit from this general education biology class. There were high level vocabulary words that he was unable to understand. And the special education teacher testified that they were not able to modify this curriculum, this biology curriculum, down to the student's level. So the charter was contending that he could not get an academic benefit from this general education co-taught biology class. That's why they moved him to, or offered to move him to a different special education biology. Well, the parent believed that the biology was the least restrictive environment, did not provide consent to the IEP, and the ALJ held that even though the student's reading level was at a first grade kindergarten level and his goals were at a kindergarten first grade level, he was still meeting his goals. He was meeting his reading goal, he was meeting his writing goal, he was meeting his math goal, and those goals weren't centered around biology in any way, but he was meeting them, indicating he was receiving some academic benefit from his general education classes. And the quote I wanted to pull out from this one was that the ALJ said that the student's teacher failed to understand that student was not expected to master the 9th grade biology content. He was expected to make progress on his individual goals. And they also held that modifying the curriculum, the charter's inexperience to modify the curriculum was not a justification to remove the student from the co-lab class. So the student prevailed, and the ALJ held that this co-lab, this co-taught biology class was in fact students' least restrictive environment. Our next cases, Marcy is going to discuss.
Yep. Thanks, Michelle. Hi, everybody. So the next case that Tillman's going to pull up the slide for me on is the Parent versus San Francisco Unified School District case. This case has to do mostly with a dispute over residential placement, where the parent sought a residential placement for their kiddo, as you can see here, at the time of the hearing, was a 9th grader with autism and intellectual disability. I thought this case was interesting because obviously residential placements cases are usually always interesting to follow. And in this particular case, the student's attorney had 2 expert witnesses testify on their behalf. Both of their experts were IEE assessors who had actually assessed the student, and both of the IEE assessors actually recommended that the student be placed in a residential treatment center. That being said, the district actually, the student was not able to prove to the judge that the child actually required a residential placement center, even though there were 2 experts that testified saying that the student needed it. So let's go on to the next slide to kind of like unpack some of these issues in this case. As you can see, there were a number of issues, and the district actually prevailed on issue 1 that's over here about behavioral intervention. The district prevailed on issue 2 about the quiet room. And as I mentioned, the district also prevailed on this issue of residential placement. So in terms of the first 2 issues here having to do with allegations that the district did not timely provide the parent with information. I'm curious, do any of you ever have cases where parents allege that you don't timely provide them with certain information? Like, hey, you should do this quicker. I need this information about my child's behavior at school. That's what this case had to do with, for example. Parent alleged that the student's behavior resulted in the legal obligation for the district to complete behavior emergency reports. And the judge in their analysis here went into the legal obligations to develop those BERs. We know that we're required to complete a BER whenever there's an emergency intervention that staff uses to control a student's behavior, right? So physical management, stability holds, restraints, escorting a student. And that we have that also when we do use a BER and it involves previously unseen behavior, we have to then have an IEP meeting. So here the student had the former behavior was, spitting, biting at school, and then the student's new behavior was a little bit different. But the judge said that there was no requirement. That the school district testified in the case. Staff said, hey, we send home a daily communication log. We send home parent emails. We also are taking behavior data on a daily basis, and we share that behavior data with parents. So we are definitely timely communicating with parents. In this case, the family alleged that the district was improperly using a, quote, quiet room. And the testimony from parent was sort of made this quiet room look like a very bad place for the student to go. But actually the quiet room was a room that was used by all of the students in the particular classroom, and it was a sensory room. And so the judge said that there was, first of all, no legal obligation to inform parents when student went to the quiet room, right? So sometimes we have parents alleging, hey, you need to notify me about X, Y, or Z. So I thought it was interesting in this case that the judge said, hey, there's no legal obligation, nothing in the law that says school districts have to notify parents each and every time a student is accessing a quiet room. Now, in terms of the residential placement issue in this case, which was to me the central issue, we saw testimony from school staff where they recommended that students' placement be changed from a mild moderate classroom to a classroom called the extensive support needs classroom. And parents said, you know what, at home, we can't control our child. The parents were testifying in this case that the behavior at home was deteriorating to the point that parents felt unsafe. Parents even testified that they felt trapped in their own home. They felt like they could not even leave the home. They weren't safe. Mom actually provided some very specific testimony that at home, their child was all of a sudden being very mean to the dog, and in fact, even tried to physically strike the dog. So the judge really focused on that we have testimony about school. Here's the behavior that we're seeing at school, parents' testimony about what's seeing at home. And the judge really focused on those two experts, as I mentioned, the two IEE assessors. I don't know if you've ever had an IEE by Dr. Lethko. I myself have not, but Dr. Lethko was the IEE assessor in this case. And what the judge focused on was that Dr. Lethko, the IEE assessor, only observed the student at school for approximately 1 hour. The judge is like a 1 hour observation, along with the other stuff that the assessor did, was really an insufficient observation. And the judge also focused on the fact that the IE assessor was not able to talk about what was the curriculum in the extensive needs classroom, what were the academic supports in the classroom, and what was the adult to student ratio. And since Dr. Lethko at hearing wasn't even able to talk about what the extensive needs classroom looked like, then the judge said, well, there's really, that's really not very credible testimony. You're saying that a kid needs a residential, but you're not even aware of what program the district has actually offered as their FAPE offer. And so as you can see here, the remedies, student had filed this due process case in order to get the remedy of a residential placement. And the judge said, no, you're not going to get a residential placement. And the only remedy that was ordered was 30 hours of behavior consultation. And the judge ordered that because there was about a 1 month time period from April to May where they were having IEP meetings and everyone agreed this child needs a different placement. Mild mod is no longer appropriate. But even though the team agreed to that, they didn't offer a new placement until May. So for a 1 month denial of FAPE, 1 month, right, where everyone agreed that he should be in a different placement, the judge ordered that 30 hours. Let's go ahead and move on to the next case. The next case I'm going to talk about is Parent versus Sonoma Valley. This case was Jennifer Kelly. It was a 5-day long hearing. And the opposing counsel in this case was Natasha Washington. We have a number of cases with Natasha Washington, so I always like to see, well, gosh, who are the opposing counsels? In this case, Sonoma Valley prevailed in their case. This is a case about transition plan, right? We have a 19-year-old kiddo, got a diploma from high school, but as you can see here, some significant disabilities. This student was functioning in terms of reading at a 2nd grade level, and that was the key thing that was brought up in this case. In this case, basically the allegation is, hey, Sonoma, why did you give my child a high school diploma and graduate them from school with everybody else when they're reading at a 2nd grade level? Clearly, parent claimed that's not appropriate. Parent provided a lot of testimony this year, and parent was like, the teachers are making up grades. They're just giving grades. As you can see, there's a 3.22 GPA, even though the student has very low reading skills and very low skills in all areas. So parent was like, teachers are lying. These are fake grades. There's a modified curriculum. So clearly, there should not have been a diploma. Also, in this case, there was another IEE assessor, Adrienne San Milan, which we have used a number. We've had to do IEEs using her. She is good to use because she's a Spanish speaker, and that was at issue in this case. San Milan testified. The IEE assessor said Sonoma should not have given a diploma This girl does not have basic skills. This child is not able to function independently. Well, the judge did not agree with anything that San Millan said. A second case here where the IE assessor's testimony was given very little regard for many reasons that were similar to the reasons I just talked about in the prior case. San Millan had a very limited observation. Also, San Millan in her IE assessment, she did not get any rating scales for the adaptive rating scales, none of the rating scales from teachers. And the ALJ actually said that her testimony was not persuasive because San Millan said that in order to have a diploma, you have to be able to be prepared for independent living to get a high school diploma. And the ALJ said that wasn't true. The ALJ cited all of the law in our education code that actually says that districts can establish what their graduation requirements are. And in this case, the student met the graduation requirements. And so it was totally fine to give her a high school diploma. The transition plan was appropriate. And so Sonoma, in this case, prevailed on all issues. We have 2 more cases, and I'm going to pass the torch on to my colleague, Citlali.
Hi, everyone. I'm Citlali. We're going to jump into Parent versus San Diego, which actually speaking, it has to do with 3 issues. It was a 17-year-old in the 11th grade. This is a great case for those of you who have right now students that are considering private placement, or like the parents really want private placement. But the student was SPED eligible in autism and other health impairment, but they were at the parent privately unilaterally placed the student in a non-public school, specifically called Winston, starting April 2024. And they were there up until the 2024-2025 school year. But there were 3 issues that the parent brought up that the school denied FAPE. Specifically, I'm going to focus on one, that they failed to offer an appropriate plan to transition back to public school. This actually goes back to a May 8, 2024 IEP that the district created. But OAH had actually already litigated this case the year prior. The student brought that up, saying that it was an inappropriate IEP plan for the 2023-2024 school year. And the OAH in that case did find that it was an inappropriate plan for the student. And so when the parents brought that up again this year for the 2024-2025 school year, the school district said, well, why are we relitigating this case? We've already litigated it. And the judge actually disagreed with the district and stated that, well, that was for the 2023 school year, 2024 school year. This case involves, it's the same IEP, but because it was used during the 2024-2025 school year, it still counts. And what I mean by that is that in the school, the child left the school in April, but parents had requested the IEP. So technically speaking, when they re-requested a transition plan in December of 2024, I believe it was, yes, then the May 2024 plan was still in effect. So even though the parent requested a new one and the student was no longer in the district's, it was in now, the student was now in the private school, they were still, technically speaking, the last consented to IEP was the May one. So that was the one in effect. And the ALJ said there should have been a better plan for the student. There wasn't enough mental health services because the student had severe anxiety resulting from school and task refusal. However, when it came to the remedies, the parents said, well, can I have the next slide, please? Sorry. The parents requested the tuition for the time that the student was not in the district, so $35,830. The ALJ actually lowered that reimbursement to $21,498 because when the parents requested a new to get back into district in December during winter break, December 2024, once the district came back to school, the special ed director was like, okay, yeah, let's schedule that IEP. But then the parents kept dragging their feet. They didn't respond to emails, and the next one wasn't until they were actually in due process that the parents said that, okay, let's do February 3rd. But that was the day that they were supposed to be in due process for another case. So they were just having a hard time with the parent scheduling this. And so the ALJ stated that they had to lower the reimbursement to only include tuition from August 2024 to February 2025, which is when they were supposed to have the meeting, but then they didn't. So yeah, that's where the reimbursement was lowered from 35,000 to 21,000. May I have the next slide, please? So this case, this is Long Beach versus parent. So that means a district filed against the parent. And this is a great case for those of you who have a student right now who has a lot of, like, unfortunately, a lot of behavioral issues, and looking into putting them into an IAES. But so here we have a 17-year-old as well. They're in the 11th grade, and their SPED eligibility is ED. They're in a special day class for most of their classes except for one general ed course. So the student actually had was on track to graduate from high school. He was doing well with a lot of his goals academically. However, he had a behavior of hitting, choking, biting, spitting, punching, pushing, and threatening others, as well as hurting himself by banging his head against the wall and punching himself. And it was just unfortunately a lot of issues. And so he had over 20 behavioral incidents. And there was two between September 2025 and February 2026. And there was two issues here. The district says that the first one is that that the student presents he is likely to seriously injure himself or others. And the second was that their IAES placement was appropriate for him. May I have the next slide, please? Thank you. And so the mother actually did not contest the first issue. She said, I agree, my child is likely to hurt himself or hurt others, right? But what she did contest was the actual placement that the district wanted. She stated that she didn't feel that the placement was appropriate for her child. She said that it was too far from her home in Long Beach. It was about 25 minutes away. But the district showed that Rossier, which was the non-public school placement for 45 days that they wanted to send him to, was really focused on really fit the child's goals. And so like there's small classroom sizes, there was aides everywhere to like really support the student. And so the ALJ agreed with Long Beach and stated that the private school placement was appropriate for the student. Thank you.
Well, thank you all for joining us today on Lunch with Legal. We have here on our last slide the QR code for our next Lunch with Legal on May 15th. And this is going to be a very special Lunch with Legal because to commemorate the end of the school year, another school year gone by, we'll be having some special prizes for attendees. So please join us on May 15th from 12:15 to 12:45. We really look forward to seeing you all again. And in case you want to catch up on our prior Lunch with Legals, we post all of the recordings of the Lunch with Legal sessions on our YouTube page. We are at Higher Gutierrez Law on YouTube, and you can connect with us on other social media as well. Here's that QR code again for the next presentation on May 15, 2026. We'll be looking over the decisions that were issued from the April batch of decisions. And we'll be going over the takeaways that are important for school districts like we did today. So thank you all for joining us again and hope to see you at our next event.